Good afternoon, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the culture. We're excited to have you join us once again for the standard time every single week, and we're thrilled that we get to be in conversation together as we navigate all the things that we're experiencing in the world. It's the last month of the year. I cannot believe it. We're going into our third season it'll be. Oh my goodness, where did the time go? We started in the midst of this very uncertain COVID pandemic, and we've been with you with our legal experts each week. So we want to thank you and express our gratitude for the season of reflection and remembering. We appreciate your participation, sharing the show, and giving your feedback and letting us know what you've learned as a result of our content. So with that said, we're going to let our co-host share a little word of welcome with you. We'll start with Royce Russell Esquire. Welcome, Mr. Russell. How are you doing today?
Welcome, everybody. What it is, what it was, and what it will be is what we'll discuss today. So keep your ears and keep your pen and paper handy because we're going to drop some knowledge, as we always do. But it's always interesting how things evolve in the name of reform, especially criminal justice reform. What's up, Ed? Talk to me.
Yeah, absolutely. Hi, hello everyone. Good afternoon. Welcome to the show today. Buenas tardes, mi gentes. Glad to have you here today. You're definitely going to find this information, I believe, enlightening, educational, as well as fulfilling. So, welcome once again.
Absolutely. So, as we talked about last week, it was a lot that we packed into the show, and our legal experts were able to break down some information. We touched on a particular event that was happening in the news around Brooklyn. So, we're going to bring it back to Brooklyn, and then we're going to talk about another unfortunate incident that has happened and taken the life of a former NFL player. But we're going to start with this story. Brooklyn judge
Brooklyn in the house.
curbs
Without a
defendants'
doubt.
rights to challenge DAs on evidence sharing. This is pretty interesting. What does this mean, especially since we've been talking a lot about understanding this part of the justice system? So, what say you, legal experts?
Well, basically, what's going on here is the following. Back in 2019, there were several criminal justice reforms that took place, new legislation, amendments to existing legislation. In particular, one of the biggest reforms was discovery. And what do I mean by discovery? In every criminal case, there's evidence, right? You need evidence to accuse someone and convict someone, right? And so that may consist of various police reports, 911 recordings, video footage from either from the officer's body cam or that has been collected from a camera belonging to some business nearby. Reports that were taking place from a witness interview, whatever that may be. So you have a variety of reports. You have tons of material in many cases that the prosecutor has. Before that reform, the prosecutor could hold on to that evidence and not disclose it until the proverbial eve of trial. During that time period, you're going back and forth to court. They're making your client offers of settlement on your case. Your client is like, no, you as a defense attorney are like, but listen, so what do we have in order to fight this at trial and win? And in some cases, in most cases, without that crucial evidence, you're put in a very compromising position as a defendant and as a defense attorney representing that individual. So in 2019, there was a law that said that discovery has to be shared with the defense automatically after the arraignment. And so now a lot of the district attorney's offices, not just around the city of New York, the most populous city in the state, but around the state period, DA's offices now have to, work hard to get this documentation together, provide it to the defense, and then after that, file what's called a certificate of discovery compliance, basically declaring to the court that it has satisfied all of its obligations under the law, criminal procedure law, section 2245-20. And so, and I believe under that law, you have 20 days to furnish that to the defense if the person is in custody, and 35 days if they're not in custody. And a lot of the district attorney's offices around the city have been complaining that timeline is very short, it's cumbersome, and it's causing them a lot of problems in terms of providing that material to the defense in a timely manner. I'm going to stop there, and I'm going to let my colleague Royce intercede before I continue.
So let me just speak to a couple of things that you spoke about. One is, and I'll start backwards. I'll start with your last statement, which is that DA's offices might be clamoring as to the timeline. So I look back to politics when I discuss this part of it. I would hope that the legislators in New York, the body of politicians that ratified, that came to the table and voted on this discovery time limitation as to what the law would look like in the future to reflect criminal justice reform, consulted experts, prosecutors, defense counsels, and came up with a timeline that folks thought was reasonable. I am assuming that this was not done in a vacuum.
Now, if I can just piggyback on that, right. I was around as an executive of a DA's office, and these district attorneys' offices all have a legislative person in their office that spent a lot of time in Albany talking to these legislators before these reforms took place. So Royce is absolutely right, whether or not it had the desired effect. But I got a feeling it did, because if the DA's offices is telling them that, listen, this is how much time we need, or we can live with that.
Exactly. We know that district attorneys' offices, and I'll share this with our viewers, are probably more in line, more prepared, have a hierarchy for which they can participate in this type of discussion with politicians in reference to what is a valid timeline versus defense counsels, versus any bar association, versus any defense organization that can say, we believe that 10 days is the timeline versus 20 days. However, it shaped out that 20 days was going to be for defendants that were in, 35 for defendants that were, or the accused that was out. We never heard any story where there was people challenging that, and it was a big upcry. Most people and most of the stories went to bail reform and whether or not someone could be released if they committed a felony and they already had another felony on. The reform focused on that. Everybody was a champion as to the discovery, because the motivation of this, as you stated, was that defense counsels like myself and yourself and you were getting materials not eve before trial, but a week before trial, 5 days before trial. And inevitably, I would have to ask the judge for more time to review this new material. You would do the same. So how do we stop that? And then upon reviewing that material, then we may be able to come to a resolution. What are the best practices to have that happen? Is to give the information over sooner. So one, I really don't buy the argument that, and I don't want any of our viewers to buy that argument as well, that we don't have enough time. All right. That is a non-argument for me. Not only was this time argued and ratified, there is a section of the law, if I'm not mistaken, that you can request more time. You just got to file a motion.
Yeah.
And you have to show a good faith basis why you need more time. However, over and above that, you're working with the police department. If the police department's motivation is not just arrests, but actually convictions, then they should be able to help you get that paperwork. And what we're not talking about, which I believe if I was a judge and as a former prosecutor in state and federal level, if I went to the judge and said, Judge, we have the body of the paperwork that is necessary to prosecute this case, and I've given that over to defense counsel. However, what we don't have is the forensic report that went to chief medical examiners, the forensic or the ballistic report that went to the ballistic office or what have you, or went to Albany, wherever it went. That is what we don't have. Then I think reasonable minds would be reasonable in, all right, that's what we're missing. And that may not be the determining factor. But what we have here is your standard 61 complaint reports, your victim statements, witnesses, things that are within the control of either the DA's office or the police department that is falling by the wayside. Hence, we have this new law that says get it timely or there will be repercussions. And the only way this really works is that if there is repercussions, because if there isn't repercussions, then we go back to the usual form where the DA controls when the discovery is given to you, how late, how soon, what is given to you, such as redacting certain material that might be important to your case, rather than using a protective order, which says basically that your client can't take the material home because it's sensitive, but we could surely look at what the material is. So we're protecting it to a degree as they do on federal court. And now, if you go on, Ed, you can.
So hold on. Before you continue, I want to, of course, say good afternoon to Deborah and to Kevin for always being here. But for those who might not understand why this is so important, if someone is on trial and there's something that could potentially help or hurt, this is a challenge to that evidence sharing. So they understand, like, it's something can be brought in, but if it's brought in too late or it's not able to come in, how that can affect your case. So let's just break it down a little bit more.
Well, let me to your point. It's not necessarily when you're on trial. This is stuff that should happen pre-trial. It should happen every single day that you walk in the courtroom, all the way up until you have trial. So if I'm giving you 20 days to get me everything that I need so I can have a conversation, let's take it away from the criminal aspect. You're buying a house. Buying a house, you want the inspection of the roof. You want there to be a termite inspection. You want to make sure all the appliances are together, right? So if I don't have that material, and then on the 15th day, you're like, all right, give me your money. That's a problem. I need that material before I give you my money. Same thing here. We don't have to wait till the closing date when I get ready to buy the house for you to hand me that material. You need to hand me that material beforehand. And now in the criminal justice system, now what is being said is that you need to hand it over within a certain timeline. So now I can read it. I can inspect it. I can decide I want to buy that house. I decide if I want to take a plea. I decide if I want to go to trial. And what you said, Dr. Grant, is even more egregious, that you're actually on trial. And then this evidence that they should have gave you long time ago within the 20 days or 35 days, all of a sudden comes up and they're trying to introduce it. Oh, that's a big no. That's like next level no. We didn't even get there. We on just the no. The other no is like Matumbo no. Like, yo, block shot. We just on the other no.
And in terms of repercussions here, because basically this article really focuses on a pilot initiative, if you will. Just to explain to the audience, pretty much all of the courts in New York have a particular judge that supervises the other judges, right? That's higher ranking and controls that court. And here in Brooklyn, the supervising judge of Brooklyn's criminal court is a judge named Keisha Espinal. And apparently there's a pilot initiative that places upon the prosecution and defense a obligation to confer, to discuss, to figure out what may be missing from this discovery that was presumably already provided. And it basically says that failure by the parties to confer and file the aforementioned letter that they've met will be, or conferred, will be deemed by the court as notice that there were no issues raised with the certificate of compliance filed, and will constitute a waiver of any such issues at a later date. In plain English, basically it says that if you don't raise a problem with what was provided to you as a defense attorney, then you waive your ability in the future to file, a motion to dismiss, say, for this item missing from the discovery that you should have received. It kind of puts that onus back on the defense bar, and the defense bar, of course, has a problem with that, because they're saying, listen, that's not what the law says. The law says you're supposed to provide me with all the discovery, and if you don't, then there will be possibly a variety of consequences, ranging from you not having an ability to call that witness for that report that you didn't provide me in a timely manner, to possibly the case being dismissed because the prosecutor said they were ready when they really weren't, because they hadn't provided all of the information that they were obligated to provide.
Can I stop you right there, Ed? Now, we're on Speaking Legally, right? And I think that we are a fair and balanced show, right? As fair and balanced as you can get with a cultural twist on it. So on the face, and we always talk about critical thinking, right? On the face, one might say, well, why do we have this? Why is she even interfering? Why is the judge even interfering with a law that's already settled? So being fair and balanced, I will lend my intent and motivation to the judge. Don't know if it is, but I'm going to lend it. Now that has a time and an expiration. You have to get interest if I'm lending you my intellectual property. But judge, I just want to let you know you can have it for a moment, right? So, Dr. Grant, you believe in that, right? That's right.
I do.
That's right. That's right. No comment from you. That's for sure.
At all.
That's right. So, lending the judge my intellectual property, which is the motivation for this intervention, is based upon defense counsel, guys like me who got gray hair, who's been around for a while, defending these cases, knowing what should be given to them, knowing that the district attorney's office has not given them what should be given to them. Defense counsel does not raise it and say, wait a minute, I'm supposed to have 3 aces. You only gave me 2 aces. Defense counsel either knows more than the DA, or the DA is just not sharp enough to realize that you're supposed to have 3 aces, or the DA realized you're supposed to have 3 aces and think that the defense counsel is not sharp enough to know that you're supposed to have 3 aces, right? And so defense counsel then stays quiet. The 20 days go by, the 35 days go by. It might even be time for trial. Then defense counsel files a motion saying, wait a minute, judge, this case has to be dismissed because the DA didn't give me those 3 aces. And the judge is saying, well, why didn't you bring up this before? Like, what's going on here? You should have brought this up before about the 3 aces. Why didn't you bring it up? And defense counsel is saying, judge, I don't have to bring up 3 aces. I don't have to at all. The law says what it is. The DA knows what they need to do. They didn't do it. I have a right to stay silent, and I have a right to challenge this prosecution based upon them not doing something. So I'm lending the judge my intellectual property. I don't know if this is the motivation. So the judge says, wait a minute, we're not going to allow that. And the reason why I'm doing that, Ed, is because you and I discussed the article before. The judge talked about too much motion practice, that a lot of motions were coming in. And then from a cultural standpoint, not to say that all the accused are African Americans or people of color, but the case comes out of Kings County, very diverse, multitude of people of color there. If anybody thinks that we want our community less safe than anything else, I don't want, a robber, a rapist, a murderer to be able to get out because the DA failed to give one piece of document. The defense attorney knew that document wasn't brought forth. didn't say anything, and then I mean, like, it gets very, very conflicted. As a defense counsel, I'm gonna do what's in the best interest of my client. But as a person in the community, you could see how it can get conflicted. So the judge intervened and said, no, before that certificate is filed, or either after that certificate is filed, you need to meet one more time to make sure that everybody got 3 aces. And if you don't have those 3 aces, and defense counsel, you don't say anything, then you can't come back to me later.
And I just want to jump in. Rolanda, great to see you. And Ryan was saying that loopholes are always there for both sides. And there are always ways to legally cheat. Not sharp enough is a good example. And they prey on what you don't know. All interesting points of view there, Ryan. Thank you for sharing.
And that's why I wanted to bring it out, because both sides can do the same thing. The prosecutor's like, oh man, that's a young defense attorney. He don't know it's supposed to be 3 aces. I'm only giving him 2. Old wisely defense counsel like, hey, that young prosecutor, he don't know it's 3 aces. He only gave me 2. I'm a wait. And then I'm going to implement this motion. Now, here's the funny thing about this article, and I'll give the floor back to you, Ed. The article speaks to, and the judge speaks to, motion practice. The judge speaks to,
I believe the judge's spokesperson.
Yeah, well, the judge's spokesperson got them speaking points from the judge, or else there's a problem, right? So you can cut it up any way you want to. You know what I'm saying? You can dissect.
There we go.
You can do whatever you want.
To be fair.
I always say, Dr. Picado, use surgery. You can cut it up any which way you want. Neck bone connected to the hip bone, however you want to do it. They're looking at this article from a defense prosecutor waging of wars, and not really looking at it from a justice standpoint. Justice requires that everyone has the right to confront their accusers. Confront means a variety of things: on the witness stand, paperwork, you name it. And so if we're about that, then maybe, once again, Judge, this is on loan and it's heavy interest on this intellectual property, is that maybe her intervention should go something like this. You have to meet and confer. And after 10 days after meet and confer, the situation is not resolved, file whatever motions you have to file. Right? Because then what you have that initial 35 day. Nobody can sleep at the wheel and act like the other person don't know. In that conferring, that joint letter that you have to write, you have to hash out, hey man, I'm still missing that 4th ace. But then there's a time limit to that. That 4th ace has to be delivered within 5 days of having that meeting, because then I bring it up, I'm missing the 4th ace, and then how long we go? We just go on forever? Like how long do we proceed? Do we don't proceed? What's going on here? And the reason why this is important is because, and Ed, we said we were going to talk about this, but I think we almost missed it, is this thing called speedy trial.
Yes. And
right? Hit the floor running. Go ahead.
Well, just for the audience, I'm sure many of you have heard of the right to a speedy trial under the U.S. Constitution. I believe there's similar language under the New York State Constitution as well, that an accused has a right to a trial, a speedy trial, or trial within a reasonable amount of time. So in misdemeanor cases, it's supposed to be 90 days. In a felony case, it's supposed to be 180 days. Those timelines aren't as simple as they sound.
No, they're not.
And the reason why it is not simple is that deadline is only triggered upon basically the prosecutor saying that they're ready for trial, and the clock starts ticking, and it gets kind of hairy because in many cases, and New York courts are notorious for this, the prosecutor really isn't ready. They're just saying that they're ready so that the clock stops, so that, okay, because what happens is if a prosecutor says, oh, I'm ready for trial, and the court cannot do a trial, meaning that the court has too many cases on its docket, doesn't have jurors available, the defense attorney isn't ready, or the parties are negotiating, all those things can stop that clock. Okay. And so in terms of what we're talking about here today with this discovery, what happens is after that prosecutor files that certificate of discovery compliance, then it's normally followed by either this statement on the record that they're ready for trial, or they will file a document, certificate of readiness. In either case, that's supposed to stop that clock. But if you haven't complied with discovery, the question is are you really ready? And if I file a motion to dismiss after a certain amount of days, those days that we talked about, then under the law, that's supposed to happen. That case is supposed to be dismissed. What's actually happening, from the test of the law so far, some of the cases that, have come out have been more in favor of the prosecution, in that judges will say, well, listen, I know that this document wasn't provided, but the prosecutor showed that they provided the documents that they had in good faith, or either sought the documents and in good faith and didn't receive them in either case. I don't really buy that.
That's not what the law provides. So, like you said,
it's not what the law provides.
That's right. So the judges are now stretching, and that's why some people say, "Oh, you want me to go in that courtroom and have two prosecutors, have the judge and the prosecutor try the case?" Because now the judge is stretching this definition. 20 days, 35 days means 20 days, mean 35 days. It doesn't mean 20 days where you acted in good faith and then you get 5 more days of acting in bad faith, right? You know what I mean? There's no footnote to the law. 20 days is 20 days. So you did get document A, B, C, D, E, F, and G. All right. So you have half of the money for the closing of the house. We need all the money for the closing of the house, right? Like, and the reason why I use that, because that's a real example, right? You want to purchase something, you want to buy something. Nobody's taking, hey, you can't walk up, yeah, man, look, in good faith, man. I know I owe you $25, but I got $20. That's not happening.
And I had a real estate transaction one time where we executed the contract and everything, and then it took forever for the buyers to cut the check for the escrows. Like, where's the money? You're right. You're right. The example is analogous. I mean, this article triggers a lot of little points, because this whole thing with being ready for trial, it's been notoriously abused in New York. You'll have prosecutors say they're ready, and they'll say, well, I'm not ready today, but I'll be ready in 2 weeks. Well, the judge can't schedule the trial in 2 weeks. What happens if the judge can't schedule the trial in 2 weeks and schedules it 6 months from now? The clock only runs to the 2 weeks and then it stops.
Right. And so
people need to understand that.
That's right. So there's been discussion about that. So I'll reiterate it again. Ed comes in as the prosecutor. He says, Judge, I am ready. And then the judge drills down, well, what do you mean ready? We call witness today. Well, Judge, I'm ready, but my witness could be in tomorrow at 3:00. I wasn't really sure whether we were going to. And so the judge says, you know what? At 3:00, I got something to do. And then the prosecutor says, well, Judge, he could be available on Friday. Court says, can't do it on Friday. Now, court is making a decision that they can't do it. The prosecutor is telling you when their witnesses can be ready. You, as the accused, you sitting there standing there talking about, well, I know that I want this clock to keep on running. And I hear you guys talking, and you're talking as if this clock is not going to run. And guess what? So then the judge says, all right, well, we can't do it at 3. We can't do it on Friday at 2:00. So therefore, we're going to adjourn, as Ed said, we're going to adjourn into January. Mm-hmm. And so you as the accused, you're like, all right, so how much time is coming against this 90 days or this 180 days? And the judge says 1 day or 2 days, because he could have been ready at 3:00, but we can't do it. And you're like, what? What kind of 3-card Monty is this? Like, you know what I mean? Like, where is the red card? Like, what's going on? So now that same type of ideology can be used with discovery. Hey, look, we'll toll the time until discovery is handed over, because you do want discovery, right, Mr. Pichardo? Because discovery is going to help you and your client, right? You don't want to go to trial today without the discovery, right? You say yes, I want the discovery. Okay, well, since you want the discovery, and it's in the best interest of everybody,
We're
in
gonna put it
the
on you.
quote unquote interest of justice, right? They jam it on you. We're
Yeah.
gonna toll the time. No time is counted until you get that discovery. So those
Mhm.
days go by. Now Ed comes back in and is like, yo, where's my paperwork? 30 days went by. 30 days
Crickets,
went by. As we call it, not crickets, cicadas. They make a little lot of
cicadas.
noise.
Chit, chit.
You know what I mean? They make a little lot of noise. Same result, right? Cicadas all over. You know, and so now noise is being made, but nothing is being done, and that's important when you're the accused. Or as you say, Ed, someone comes in, and I've had this happen 1,001 times, more than I can count. If it's the domestic violence, or if it's something that happened in the neighborhood, the DA says they're ready, and my client is like, yo, ain't no way they're ready. Yo, so and so's in Jamaica. What are you talking about? I was just on the block. He ain't been around for 3 or 4. And then you challenge. You say, well, Judge, I don't think that's true. I think the complaining witness has been in Jamaica and it still is in Jamaica. And then the court starts to test down on that.
So interesting, because Ryan says, don't give up your speedy trial rights. If they are not ready, then motion to dismiss. They will trick you with different tactics to giving up your rights. They do this every day under all circumstances which they are up against. And Deborah says, I think the system could be better than it is because a lot of things are getting pushed under the rug to where some attorneys just want to handle the case and then whatever, but not you, my brother. And Ryan says, when the gavel falls, all tricks will cease. Moreover, the judge will not risk his job or her job.
We shall hope. What's that? Spring internal, all that
Yeah,
good
hope
stuff. You
So
spring
know,
here you
eternal.
go.
you know what I mean?
Right.
You might want to hit that right now with the drum set and sound piece. But doom. Go for it.
I mean, it's all. I think a little small thing that does need to be mentioned here is that you also have to think about a number of judges. You know, are former prosecutors. You have some judges that are former defense attorneys. You know, and sometimes you also have to view it from that lens as well. You know, and once again, that's where you also have to think about who is it that you want on that bench. Okay, who do you want on that bench?
And Ed, I'll add one other thing, right? We're talking about this in Brooklyn, but for those who want to look up the article, this is resounding up in Rochester too. This is just not a 5-borough thing. So get your head wrapped around that. And what is not talked about in this whole article, and what is not talked about in reference to fair and justice, right? Because we talk about prosecutor doing things that's not just, and defense counsel, making sure that they do things and make sure they're not unjust, and making sure the rights of the defendant is taken care of, and making sure the community is taken care of. What we're not talking about, which I always speak to, is the business of practicing law, which is, if this goes down, and it goes down where I'm precluded from filing a motion because the court wants to intervene in this fashion, and it causes my client, to go to jail or suffer some damage, who's paying my malpractice lawsuit that comes through that door?
Mm-hmm.
You want to talk about cicadas and crickets? You want to talk about silence? You want to talk about silent nights as we make Christmas? Silent nights?
because we have an obligation to give zealous representation, meaning that we are supposed to pull all stops on behalf of that client. This, so we're naturally obligated to make sure we do everything legally possible, and to allow our clients to gain an advantage, whatever that may be. And let's not feel, and I never feel guilty about,
or to make sure that their rights are enforced,
or preserved.
Right?
But at the end of the day, I also want to mention that I started off this discussion by talking about what a lot of the DA's offices are talking about in terms of the cumbersome discovery. But keep in mind, these offices, when it comes to the defense attorney versus the district attorney's office, it's still a David and Goliath fight there. The prosecutors' offices have hundreds of lawyers at their disposal, ranging in experience. They have, law enforcement within their offices, detective investigators. They have paralegals. They're well resourced. So the idea of, woe is the DA's office doesn't resonate hard with me. I just wanted to be fair in talking about what was being said. Okay.
And look, and it doesn't resonate with me because guess who's precluded from being sued at the end of the day?
They are.
Guess who's shielded? Guess who's like, hey, look, I was working for the government. You can't come after me.
Unless, of course, you find some sort of egregious conduct, like we talked about
but in
last
this
week. But outside of that,
that's right. And what we're talking about today, when everything goes down, you cannot get to that district attorney. You cannot get to that assistant. And now remember, for the audience out there, you may not remember this, but Ed and I know this as defense counsel, that there was also talk about being able to allow the community to sue the district attorney for sanctions, for withholding evidence, for malicious prosecution, for violating Brady rules, showing precluding and holding on to evidence that shows that someone might be innocent. That one day you'll be able to penetrate that, because if you're precluded from punishment, then just like police or any other entity, you're going to do what you're going to do. And once again, if I'm standing there, somebody who says, hey, Mr. Russell, we should not have gone forward. You should have filed that motion. I don't care what the judge said about, and they sue me, my malpractice goes up. I'm the one that got to dig in the pocket. And I don't know if you saw what's in my pocket lately. There's a lot of lint.
Well, we don't want malpractice soon. I think this is a perfect segue before we get into the second part of the show, or the story, that this past Saturday I was able to participate in the judicial induction of one of my sorority sisters. She is now the 7th Municipal Court Judge, Keisha Lean. You see, from the primary to the election, she came out far ahead and had the support of quite a few of those in Brooklyn who want to see justice on the bench and change. So it was exciting to also see that her aunt, who is retired and a judge in Texas, came up to actually do her induction. And it was just wonderful to see how Black women are pursuing more elected positions in a variety of ways. The other young lady here, this is another judge, one of my sorors out in Long Island, in Brentwood. So there's a lot of hope that springs eternal, Mr. Russell. So I just wanted to share that with you, and congratulations to the Honorable Keisha M. Aline, who we're talking about Brooklyn. She's now in Brooklyn in this 7th Municipal Court. So I had to make sure that I gave her a shout out today.
Nice. Well, congratulations,
very nice,
Judge.
Very nice.
I wanted to, I didn't mention this to my two colleagues in disclosure to the audience, but it just came to my mind. And normally, at the beginning of the show, we try to honor those who have passed. Actually, this weekend, I learned that the wife of Clarence Avant, Jacqueline Avant, was murdered during
home invasion,
some sort of home invasion. Now, for those of you who don't know, Clarence Avant is referred to as the Black godfather of the entertainment industry. There was a wonderful documentary that was done on him that was on Netflix that I watched, during the middle of the pandemic, that made me aware of this man when otherwise I didn't know. And there were several celebrities talking about how he assisted them with their careers or interceded in any number of disputes that occurred between them and their management company or their record label, etc. Clarence Avant and his wife, Jacqueline Avant, his longtime wife, was a well-known philanthropist. And she's also profiled in that documentary. And I just want to say, rest in peace to Mrs. Avant, and condolences to the family.
it hit everyone hard. And Ryan, you asked which sorority, Zeta Phi Beta Sorority Incorporated, in reference to the Honorable Judge Aline. So thank you for asking that. And yes, we would be remiss if we didn't just talk about this case. There's a man that's charged in the death. The story is continuing to unfold, and there are a lot of people who were shocked and hurt, hearing that someone who did so much. Oh, hey, Fred. Someone who did so much for others was killed in her home, at 81. Like, who does that? Like, what? It's just sad to see, what we are witnessing in the world today. But we definitely want to take a moment to, as you said, Senor Pichardo, rest in power to Miss Avon. So thank you for reminding us about that. And then we're going
But
to
now,
get.
but Dr. Grant, with that point, right, and you take what we've been discussing, right, no one's going to be jumping in arms in reference to the person that's accused for that crime, talking about, oh, you missing a piece of paper of discovery. So, although we talk about this in an academic way, and we talk about it how it negatively affects our community, and we got to make sure that we know our A's and B's and cross our T's and dot our I's. We got to do all those things. When you put it in context and you roll it out and play in real life, it's like, this is serious business right here. This ain't play, right? Somebody can walk because of something. Somebody, I mean, look, we just took the case and we brought it to New York, whatever the discovery rules are. I'm just saying it's highly complex.
Well,
it's not a black and white.
Yeah, and none of this is black and white at the end of the day. And this gentleman right now, he's accused. In fact, I have a lot of questions about what occurred from what I've read about this case. He was actually apprehended at another home in that same neighborhood, apparently burglarizing that home. And then they connected him to what happened at the Avon household. And there's just a lot of questions whether he was acting alone, whether he was and that's where this kind of the discovery comes in, and the adversarial system that we have. Because what happens is that you have to have the evidence. The evidence has to be challenged. If it's a good case, it's a good case. If the police and the prosecutors do what they need to do, and on the other hand, the defense attorney does what they have to do, then at the end of the day, you have the judge, and all of these components come together to culminate in what we have so far in our imperfect human way defined as justice. Justice is you get due process, you get heard. We will look at the evidence more closely. We will see, okay, listen, they're saying that you did this. Let's look at what the evidence is. Looks like you did it. Oh, there's some questions here. There's some issues. Let's have a jury of your peers look at the evidence and decide whether or not. That's how it is. That's the way it works.
And I think it's. Go ahead, man. Finish up.
No. You go ahead. I'm done.
Now, I was just saying that what you're saying is important for us to understand, and why speaking legally is an outlet where we can break down what the law means, how it connects with us culturally. And when you don't get that kind of detail, if you're listening to a broadcast, because it's about ratings and ads and they just want to get news stories out, but here on the show, you're actually able to educate yourself about what's happening, what you're witnessing. And if it happens to you or your family, unfortunately, in our communities, there are very few people who have not been touched in some way by the criminal justice system, rightfully or wrongfully. Like, we can get to a whole debate about that. So that's why speaking legally is where the legal meets the cultural. So you don't have to feel like you don't know and you're at a disadvantage. You have two legal experts here every week that are unpacking and educating so that you can be aware. And of course, there's always a little bit of humor. I see Sonia has tuned in and she said, "Go Knicks." She couldn't help herself. So now we're going to move into
where they going.
Where they
going?
They beat the Lakers. That's what's important.
Where they going? Where they going?
Oh boy!
I just want to know where they going.
Moving on with sports, there's unfortunately a sad story.
Besides the Knicks, we got another sad story.
Oh wow!
Yeah, no, I digress. I digress. I digress. Go ahead. Go ahead.
Yes, unfortunately, this one is a death of a former New Orleans Saints defensive lineman. He died in police custody. This story was published yesterday. This is news that is just happening. Clearly, his mother, as any mother, is ripping the cops because she wants to know, and all of us want to know what happened that he died in custody.
Yeah, I mean, I looked at this article, and the family seems to be claiming that they were asking for him to get some medical, uh, some medical attention for approximately 2 days, and the police would simply not respond. And then next thing you know, they find out that he has died, and they want some answers as to why he wasn't offered medical care. And apparently what's this culminated from what otherwise would be more of a traffic matter than anything else. There was apparently some sort of chase. There's some allegations of resistance, etc. But once a person is placed in police custody, there's supposed to be some attention rendered to make sure that that person doesn't die in custody. And then also, this from the photo here, this looks like an otherwise healthy young man, former, NFL football player. I'm not saying that all NFL players are healthy, but, given the level of conditioning and physical attributes you have to even compete in that league, I would imagine that there are definitely going to be some questions as to whether this young man died by natural causes or whether he died from something, that was inflicted or visited upon him, not necessarily by his own actions, but by others.
Well, I mean, there's a couple of areas, right? There's one where he could have been a victim of excessive force, and that's what you're speaking to. Two, he could be a victim of, you know what, we're gonna sit you in this cell with some other bad folks, right? and and what comes out of it, right? And then number three, natural causes. But what it all boils down to in this, for as far as a cause of action, is that if you fail to give medical attention for which you're put on notice for, then you should be liable.
Exactly.
That's the equation. And I tell people I don't like to be litigious. I don't like to go to court, but here it is. You have liability and you have damages. Liability is that if the police were put on notice, hey man, I need to go to the doctor. I'm feeling dizzy. I am urinating blood. Something's not right with me. Not that he was arrested, because that could have been proper, right? That could have been speeding, whatever the situation is. That's not what we're contesting. That is not the story. The story is that he dies in police custody. In most places, in most states, and in particular in New York and New Jersey, you can call 911 and ask for EMT and ask for an ambulance, and the first entity that shows to your doorstep are the police, and you don't even call for them. So I commend them for taking on the responsibility to be first on the scene. Maybe not in this case, but just in general. But when you're first on the scene and you have a person in your custody, then your obligations only rises. It don't depart. And if someone says, "Hey, look," and I've seen it in plenty of civil rights, false arrest, police brutality, wrongful death cases that I've tried up and down the Northeast coast. Usually, when people say that they want to go to the hospital, that there is something wrong with them, either one, they're ignored, and that person that arrests them goes off for duty, and a new team comes in, and they don't know how long this person's been asking for medical treatment, so they ignore them some more. Or number two, they're dissuaded or persuaded to not go to the hospital. And it usually comes in the form like this. Well, if we take you to the hospital, that means you're going to be here longer. And if you're here longer, you may not see the judge until the day after tomorrow, because by the time we take you to the hospital and then bring you back, maybe there might be a change of duty, and then we got to get you, and then we got to bring you back, and then we got to start your paperwork. So why don't you just hold on here right now? We get this paperwork together. You'll be out of here quick now. We can get this going. But if we go to the hospital, then we got to disrupt all of that, and you're going to be held longer. And a lot of people go for that. They don't realize that this is a marathon and not a sprint when you're fighting for justice. They just don't realize it.
Yeah, I mean, I think the main reason why we're bringing this up on the show is because especially after the incident with Ahmaud Arbery, it's important that we bring light to all of these cases so that they get looked at. And unfortunately, I must say, and listen, the Northeast is an unjust place as well. New York can be very unjust. We see that all over the place. But in particular, I feel like, we have to make sure that when you have our brothers and sisters dying in custody in these places in the South, that we do what we can in our part of the country to bring light, to bring attention, because we know that attention and that light can bring some level of justice. Because when folks start having to answer questions as to what happened from those outside of the local, it brings that pressure. And so we hope that, we're putting it on our show here today. It's already on the Daily Beast, as you can see. It's making its rounds in the regular media. But we're hoping that we can do our little bit to contribute to bringing attention to this incident on behalf of this family, so that there is a proper investigation, so that these authorities feel pressured to reveal exactly what happened, what was the cause of death. And no matter what it was, who's responsible here. So, that's the reason why we're doing it. It is, at first we looked at it and we said, well, it's not in court yet. It's just, it's just a story. But, it's important that we bring light to these situations. I believe it was Sandra Bland who died in custody in similar circumstances.
Yeah. Yeah.
Couldn't explain, well, why is she dead? And we have to bring light to these incidents.
Absolutely. And, like you said, when more eyes are on it and you continue to amplify the volume, so when you start to get answers, and I'm sure this family appreciates all the help that can be given to get 31, young, prime of your life. Like, what in the world? These are the ways in which the trauma continues when we see stories like this, and why we had our expert on, Dr. Guadir, just talking about some of it and how to deal with it, and even how to talk to your kids, because who knows, children could have been fans of his, and watching when he played with the Saints, and you see this happening and there are no answers, it leaves a lot of questions. So when we have a volume, or have a voice to give volume to, like this show, it's important for us to share that information. So
And
we'll watch it.
I'm sorry, Dr. Grant, go ahead.
No. I'm saying we'll keep watching the story so that we can
Right.
report back.
Right. That's important that we keep watching the story, because one of the things that, I teach in workshops is that, all right, we catch the tragedy at its highest point, and then next thing you know, it kind of filters off. And if we see it from beginning to end, then we can be more sensitized to how things come about. And we, as Ed said, we can shine light all the way from the beginning to the end. Now, what is interesting is, what will the NFL do in regards to this? We had the shooting in Detroit, right? Those kids were shot in the school in Detroit, and they played that football game in their honor. And Detroit actually won that football game. They were undefeated in the loss column up until last weekend. And so, you heard a lot of tributes to that. And then, I feel, for the kids, and I'm not saying that was wrong. That was the right thing to do. That was in their heart and in their minds. And they did it with the NFL, salute and A++. So now you have a former NFL player who dies in police custody. And I don't care what he did wrong that led to his arrest. The fact that he died in police custody, who's going to write that on their cleats this week? What are the Saints going to do? Are they going to have a rally around game and understanding, hey, look, this was one of our fallen soldiers here, brothers, Certain things get the spotlight and certain things get the flashlight.
Mm.
And speaking of spotlights and flashlights, and I think you've spoken about this, Royce, that sometimes certain cases and incidents get
Oh, Lord
the
Jesus. Yeah.
attention that they don't really need, right?
Right.
All this week you've been hearing about this Jesse Smollett trial, and that's why I think it's important that we highlight stories like this, because sometimes you have you have individuals doing things to get the attention that's not really deserved. I don't know if both of you agree. I mean,
No, I agree with it.
Well,
I mean, let's have the Epstein trial. Let's vilify that and have an analysis on that around the clock. Let's dissect that. Um,
I'm also you mentioned the shooting in Detroit. We haven't dissected that because there's layers, and maybe we'll touch on it as that develops, because the parents, I believe, were arrested because they bought him a gun and the teachers had concerns. So he was actually in the school building with his parents
right.
the
well, the
day it
big thing,
happened.
yeah, and the thing is they brought concerns to the parents, and the parents failed to disclose the possibility of him being armed. And they found like text message exchanges to that effect.
And a drawing on that day. He said, "Oh, that was part of my comic book. That's my comic book series." I'm gonna tell you right now, a person of color draw pictures of somebody getting shot in that classroom. Yeah, all right, you be at the 42nd precinct sitting down having questions,
Oh, what?
right?
Exactly. It would
Well,
not have
well, well, well,
happened.
well, let's talk about the absence of metal detectors at some schools versus others, right?
That is correct.
Hmm.
I mean,
So
that's been an issue in New York City for a good minute,
And it's
so
what I have to chuckle at is that the family was found at a friend's place, right, or the the library or some place, right? And oh no, they weren't fleeing. They didn't know anything about this. They just happened to be over there. Man, really? Is that
boy,
what we rolling
like,
with?
no, my
that's the
understanding is
real.
they in fact they fail to appear,
Some,
and
but
yeah.
the excuse was that they didn't know anything about it. They weren't fleeing. They just happened to be stuck in the stacks with Little Red Riding Hood books. You know what I mean? It's just like,
Look,
come on, give me a
that's
break.
when you do the cultural. Come on, son.
Right.
Because
You know what I
that's
mean?
just when you get that. Like,
Yeah.
oh my goodness,
Come on,
it's
son.
so sad to see the disparities continue to show its face. But it'll be interesting to see how this plays out. I mean, you have all of these families right at the holidays. Their kids were in school once again, and
Now, here's a funny story, right? Or not so funny. Our vice president, when she was the U.S. attorney in California, there was a law that the parents would get arrested for the kids not going to school.
Mm.
So
Mm, mm,
let's
mm.
just chew on that for a little bit. These parents obviously should be held accountable.
Well, they were arrested. There's a $500,000 bond, I believe it is, that is out on them. So to be continued. I'm sure we'll be picking up where this leads, and I'm sure the families want to see justice. And teachers said something, and this is why we have to listen. There's too many things that can get swept under the rug, and then when crisis happens or someone acts out, like, oh, I never saw, I never knew. But there were signs, and in this particular case, it seems like there were multiple signs leading up to him having a break with reality and pulling the trigger on students, and we
No,
can't
no,
get those lives back.
no. And you
So our
have,
condolences.
yeah, and you have like these really conservative perspectives right now. You have people who, for some bizarre reason, seem to think that it's okay to give young people firearms, right? You know.
That's a whole nother
But
show.
you can
We will
give
have
young
to wrap
people
this show up.
you give young people firearms, legalizing marijuana, right? I mean, like you got a couple of recipes for a lot of disaster going on here, right? In certain
A whole
places,
lot.
a
Well,
lot.
listen, I wouldn't necessarily link the legalization of
I'm not
marijuana to
linking. I'm
this.
not linking anything together. I'm just saying that you can have those scenarios happen at the same time,
Time.
right? Right? Parents giving kids guns have been going on for a long time. It ain't just started in Detroit yesterday.
Yeah, I mean
Yeah.
the question is I mean that's a pretty lethal piece of hardware to have at a
You
young
got in
age.
Nassau County in Long Island. They're banning any marijuana shops. I don't know if you read that. They're like, not in this town. It's
Yeah,
not
some
gonna happen.
towns. My understanding, it was some towns. Like
Yeah,
some
well,
towns
right. Well,
are barring them and some are not. I
that's
think
right.
the
That's
county
right.
executives are leaving it up to the towns,
That's
and
right.
I think the
Because
law allows for the particular municipality to decide whether or not. I mean,
ration,
listen, you got
rationale behind that is driving
Mhm.
while impaired. Rationale behind that.
same as the drinking too. You
Same
got
as there you go.
drunk driving. All of that is bad, bad, bad.
Oh, I tell you, well, we're
Ugh,
praying for the
yeah.
families that have been affected because this stuff can really take your breath away. And the work that both of you do each day as advocates for those who are in certain scenarios. We thank you for the work, and we have to continue to advocate for justice, and our hearts go out once again to all the families that have been affected by violence, by crime, and that you have legal experts like Royce Russell Esquire, Edward Pichardo Esquire, that can assist you when needed, especially when you don't know which way to turn or what to do to look for justice. So we will still say hope springs eternal, that things can get better. It's gotten pretty bad. I don't want to say things can't get worse because we've seen a whole lot go on, but we do hope that the new generation of individuals coming into leadership, the importance of what we talk about on this show, who you elect, makes a difference in how the law is actually executed. So make sure you just stay engaged and don't, sit on the sidelines and not participate. And Ryan, he said death should not be a factor when getting arrested or being in jail. The police have free or low cost medical for arrested persons. With that in mind, then why foul play? Yeah, Ryan, it's a lot of questions to be answered. So thank you, Ryan, for tuning in. Sonia, Rolanda, Rich, always good to see you. We thank you, Kevin, Deborah. Appreciate everyone else who's tuning in or catching the replay. And we'll be back to close out the year together. A couple more shows before 2021 is gone. So thank you again for being here, and we look forward to seeing you next week. Any final words, gentlemen?
Happy holidays and good luck to all.
Stay safe. Be well.
All right, bye bye.